Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is solo aging and how to prepare 5 at 55 documents. Sponsored by Prince George's County Government and the Department of Family Services.
Okay, so as I said, this is Byrd Byrd's 5 at 55. And this is a common joke that we have up there. And it's the idea that individuals who don't feel like they have a lot don't really need to do a will. And that is completely untrue. And one of the things I hope everyone takes away from this evening's presentation is that it's important to get these documents done and that you'll feel better once they're in place. So what are the documents we're going to be talking about this evening? That is the will, the durable general power of attorney, a digital diary, and a healthcare power of attorney. Lastly, we're going to talk about the advanced directive or living will. So what is a will? And we have this very wordy slide on here, but the long and short of it is your last will and testament. It is your instructions of how you would like your assets to be distributed. The important thing to note here is it may or may not include all of your assets. Many people have what is called non-probate property. Those are things you might have a joint owner on, or you might have named a direct beneficiary on. So the idea is that with joint owners, the first person that passes away, their will might not apply to that asset. It's when the second person passes away that that person's will is going to apply. It's very common for adult children and parents to own property together, or very common with spouses. So my wife and I, we own our home jointly. If I write in my will, I want the house to go to my best friend, and I never want her to have anything in the house, and then I die, my wife still gets that house because of that joint ownership. If she dies first and now the house is solely owned by me, that is when the will is going to be applied. All wills, when they are applied, are going to go through probate in the county that you are living in. Most people are very adverse to going through probate, but what I say is when we have a good will in place, probate goes very, very quickly and efficiently. So what are we thinking about when it comes to making a will? First and foremost, it's choosing your personal representative. A lot of folks used to call that person an executor or executrix. It's the same thing. Maryland's just done away with those terms, and they just say everybody is going to be called a personal representative. That is probably the most difficult decision for people to do, is to decide, who do I trust to follow through on my intentions? For many people, it is another family member, but not always. Sometimes you might hire a professional to do that job. Maybe it's a banker that you have a relationship with, or maybe it's an attorney that you have a relationship with that you trust to follow through on your estate. What I always tell people in making that decision about the personal representative is you don't necessarily need the CPA or the lawyer to do it. You really need someone who is going to be available and who's going to follow through on it, because the court will oftentimes let you be when it comes to the will. And so that is where probate slows down quite a bit, is people just say, oh, I'm busy, I've got my own job, my own things to worry about, and they put things off when things go through probate. You want that person in your life that gets things done and is going to keep pushing to get things done. They're not going to say, I'll go to the bank 2 weeks from now. They're going to go today. Those types of folks, those are the best individuals to do, to nominate to do this. The other thing I say about choosing a personal representative is you should really not just be thinking about one person, but you should be thinking about a backup as well. Tomorrow is not promised for any of us, and so we really want to make sure that if the person we have nominated, God forbid something happens to them, your will already accommodates for that, and we have someone else named as well. So we have our initial personal representative and a successor personal representative if that person is unavailable, or unable, or unwilling to serve. When we talk about wills, a lot of people have this myth or thought in their head that certain people, if you don't have a will, are automatically going to inherit. That's not necessarily the case. The only people in the state of Maryland who have an absolute right to inherit is a spouse. right? They have an absolute 1/3 spousal share that they can always elect unless you take care of that in a prenup. Children, for example, don't have an automatic right to inherit. This is why wills are very, very important. You get the ability to decide who gets what, how they get it, when they get it, and if God forbid something happens to them, who's the alternate beneficiary. And that is where we'll oftentimes see people leaving things to maybe their school, their church, their favorite political organization, whatever is important to them. So you've really had that ability to think about for yourself, what sort of legacy do I want to leave behind? Who do I want to provide for? And if God forbid something happens to them, what's the alternative? So you always have that plan A and plan B in the will itself. So what happens when there is no will? Well, first of all, you're going to be on the court's time with your estate. And having worked in the court systems for 12 years now, I can tell you there's lots of great folks that work there, but nothing gets done quickly in the court system. The other thing that happens is you are now stuck with the laws of intestacy that you see on there. What that means is they basically go out and find, quote unquote, your next of kin, whether that's 19 first cousins or 7 aunts and uncles, whomever is the next closest category of relation to you, they're all going to get an equal share. So if you're someone who, for example, doesn't have children, and it's potentially going to go out to nieces or nephews or aunts and uncles, you might not have a relationship with those folks, or maybe you don't have the best relationship with this folks, but whatever your intentions are, you get to decide what happens to your estate. The big thing is there is a lot more cost to your estate. Everything's going to take more time. You're going to need to get a court order to do this. Somebody is really probably paying a lawyer at this point to get involved. And there is a higher likelihood that the family's just going to fuss, fight, and squabble over things. And that is what really drives costs up. And so that is why you see that increased family stress. So I'm going to take a pause here for a moment. And I'm going to stop sharing my screen for just a moment and see if we have any questions. And I'm going to rely on Pam to let me know who's out there and who has questions about a will.
Sounds good. Let me see. Mr. Hall, you can go ahead and unmute yourself. Mr. Hall. I think he's in a pretty loud area. Miss Miller, you can go ahead and unmute yourself. I have Miss Pfeiffer.
Tony, how are you?
Hi, good to hear from you.
I was on the call with you earlier today with the dementia group.
Oh, so you're probably sick of hearing me talk all day today.
No, not really, but I have a question. Would you suggest a will over a trust or a trust over a will?
Really, it depends upon the circumstance and what assets and what your goals are for that. Right now, when we talk about estate planning, most people traditionally used to be concerned about estate taxes or inheritance taxes or probate fees, and those things are pretty gentle right now. As an individual, your first $5 million is exempt in Maryland from any type of estate tax. And if you're leaving things to your siblings, your spouse, or your children or grandchildren, they're all exempt from paying an inheritance tax. So for most Marylanders, a really good will gets the job done. Between that and using some beneficiary forms, you're really in a good position with that will. When it comes to trusts, there are really good trusts out there that are designed to help avoid probate and accomplish other goals, but I'd always want to talk with the client about what those particular goals might be. So for example, if we have somebody who is disabled in the family that we want to provide for, that would be a really good reason to maybe consider a trust. Or if you're thinking about for yourself some long-term care planning like Medicaid, that would be a really good reason to do a trust. So for most Marylanders, I think they are good with the will, but some folks also just really enjoy having the trust because it's private, it's not involving the court system at all, and it's completely contained without having to go to probate in any shape or form. So some people just like that. I do have a little bit of difficulty justifying a cost for that because you're paying a lot of money for that trust and you're not really doing anything right now in Maryland in terms of tax avoidance or anything like that because our exemptions are so high right now. So I wish I had an easy answer like you should do a trust every single time, but it's not quite that simple.
Okay, thank you.
And then Janice Schingler, you can unmute yourself.
Downstairs and I'm upstairs. So I'm Calvin Schingler on the computer. We're supposed to switch. My question is, first, how many personal relationship, personal representatives can you have? Can you have as many as you want, or just two will suffice? But you did say if something happens to both, how do you deal with that?
So that first question, you can list as many individuals as successor personal representatives as you want. The most I've ever seen is 7, where somebody had a large family and they named all of their children just in order as successor personal representatives. That is completely fine. When it comes to that, some people also choose to like the idea of having co-personal representatives and maybe having 2 or 3 people take that job on. You are allowed to do it, but just from my own personal experience, I tend to recommend against it because if there's any disagreement amongst them, they end up going to the court system anyway, and that really just sort of defeats that purpose. But yes, you can name as many successors as you feel comfortable naming.
Okay. The next question is, you were talking about children. Suppose you have children that you considered adopted, but you never went through the legal process and you took care of them. How do you address that in this particular estate situation?
Well, it's really easy. You can name anybody to be a beneficiary, whether they're the first beneficiary or an alternate beneficiary in your will or in your trust. The only thing to be aware of is if you never adopted them and they inherit from you because they're not biological and not legally adopted, they'd be hit with an inheritance tax. They're not exempt from that inheritance tax. It's not tremendous depending upon how much money we're talking about. I would say for conversational purposes, you're talking about a 10% at most inheritance tax that they would be hit with.
Okay, Dave, thank you.
You're very welcome. Okay, unless Pamela tells me we have any other questions.
Yeah, no, that was it. I do have a question. Is the inheritance tax only for those who are not their own child, or does that include other individuals as well?
So the easier way is to know who is exempt and then just assume everybody else is going to pay an inheritance tax. So the people in Maryland who are exempt from that is, if we're talking about me, it would be my sister, so my siblings, my parents, they're also exempt, and any of my lineal descendants, so children, grandchildren, great-grandchildren. That is all of the individuals that are exempt from paying that inheritance tax. Everybody else, nieces, nephews, aunts, uncles, cousins, friends, whomever, they're all going to pay an inheritance tax with one other exception, which is just generally charities, if you're leaving things to charity, are exempt from paying those inheritance taxes as well.
Thank you.
All right, so I'm going to share my screen again, and we're gonna move on to the next topic. Okay, And so we should have up here our durable general financial power of attorney. So this document is for during your lifetime. This document will cease to be effective when you die. But the idea is if there ever comes a time during your life that you are incapacitated, you're unable to manage your affairs, you have somebody already in place to manage your assets for you. So really what we're talking about is somebody who's going to handle your money and property. They're going to manage your real estate, your investments. They can do things like protect your assets. So if maybe you didn't need a trust while you were healthy, but as they're looking at things and looking at your care, they decide at that point it'd be good for you to have a trust to protect your assets, they can take care of that for you. They have the lovely honor and privilege of bugging all the insurance companies to make sure that they're paying timely and doing what they need to be doing. And from my practice, because I do a lot of the Medicaid planning in the office, you'll see on the bottom there, apply for needed entitlements. That is probably the biggest thing I see powers of attorney doing is when somebody needs something like medical assistance or Medicaid, it is the power of attorney who's able to sign for them and make that application and get that through. So if we don't have that power of attorney, what happens is someone needs to go to the courthouse and apply to be your legal guardian of your property. Guardianships, I can just tell you, take a really long time. And in fact, I have a guardianship hearing tomorrow that we applied for back in September. So that is just giving you an idea of how long it takes to get those things through the court system. The other thing is I tend to be fairly upfront with my fees. I might charge $750, $800 to do a will and some powers of attorney. For guardianships, it's much more time, so it's much more expensive. Usually I start about $3,000, maybe $5,000 on that guardianship process. The biggest issue is with the power of attorney, you are the individual who is deciding who takes care of your property. When we're going the guardianship route, some judge, hopefully he or she is doing a good job, but they are trying to decide for you who is doing that. And with families, we know it's not always clear-cut and easy. And so quite oftentimes we will see all very good, well-intended family members really cause a big mess of the guardianship process because they all feel that they could do the best job, right? So they fuss, fight, and squabble over who has that ability to do that. So with the financial power of attorney, we also talk a little bit about digital estate planning. As we all know, we all have our passwords that we're changing all the time. We have all of our different social media accounts, shopping accounts, all of those different things. When you become incapacitated, your power of attorney has a legal right to access those things on your behalf, the same way a guardian would. But to make their job easier, particularly when it comes to financial assets, you know, if you're doing any of your banking online, keeping a digital diary with your power of attorney. So it's essentially, the way I look at it is I either use a printed out one or an Excel spreadsheet, but something that keeps track of what digital assets you have, how to access them, and what your current passwords are, so that if you are incapacitated, your power of attorney knows how to access those assets. Similarly, with the personal representative, you could name multiple individuals to do this job. You can name successor individuals to do this job. You can also, just as we talked about with that role as a personal representative, you can have this individual be a friend, family member, or a professional. I always encourage personal relationships. There's nothing wrong with hiring professionals to do it, but they will charge your estate to do it. So to try to save some of your assets, I really tell people, think about whether it's someone from church, a doctor that you're comfortable with, someone that you have a good trusting relationship to do this job. The main thing that this differs from is that when somebody is acting as your financial power of attorney, they are to be acting in your best financial interest during your lifetime, all right? So the moment that you pass away, the financial power of attorney ends and that is where something like a will or a trust would pick up. For some folks, it is seamless because they name the same person to do both jobs. For other people, we have a transition. We named one person who might be local to be our power of attorney, and then when we've passed away, we've named a different person to be our personal representative. So I'm going to pause here and talk about financial powers of attorney before we move on to the medical side of things. Okay, do we have any questions about the financial power of attorney?
Yes.
Okay.
Go ahead. Question, is the durable general power and the power of attorney, are they the same? I might
Yes.
be saying, oh, they are.
Yeah.
So if you get that, the durable, what it's called, I might not be saying it all correct. So they are the power of attorney in terms of your state, even in the financials. Okay.
Correct.
Okay.
And so a lot of folks will use those terms interchangeably. So the reason that that durable concept is important is sometimes people do temporary financial powers of attorney. Somebody, for example, might be in the military and they say, well, I'm abroad for the next 2 years. My brother-in-law can, rent my properties and collect the rent and put it in a bank account and manage that money on my behalf. But it ends, in 2024 when I return from overseas. As to where the durable is really designed to stay with you for the remainderment of your life. And it might have a clause in it when it is to be triggered, where you might say, this document is to last for the remainderment of my life, but it doesn't become effective until my treating physician certifies that I have lost capacity, right? So that is the distinction there between just a temporary power of attorney and a durable power of attorney. Most folks, whether you're dealing with financial planners or lawyers, will just call it the financial power of attorney and assume it is durable because that is the most common one, but certainly people do temporary ones for specific circumstances.
One more question.
Sure.
You mentioned about property, and you're not a real estate person, and you are the durable power, and the person expires or the person passed, and you had this property. How do you know how to divvy it up, or they should have that already laid out for you in terms of how it should go?
Correct. That is really what you're going to want that will to do, because if the will doesn't explain that, we're going to be in that laws of intestacy where we're seeing who's the next closest relative to divvy that up. Okay. But yes, as power of attorney during the person's life, you may choose to sell that real property and put it into a bank account for them to spend that money on their care. You may choose to do lots of different things with that real property, and you have that authority to do it during their life. And that power of attorney ends the moment they pass away, and then we're looking to the will.
Okay, thank you.
Yep. Any other questions before we move on to the healthcare side of things? Okay, I'm going to go back to sharing my screen here. So the healthcare power of attorney and our advanced directive. So these are two distinct documents, your healthcare power of attorney and your advanced directive. Many lawyers, including myself, we will draft them together. They will be bound together by a staple because it just makes sense. You are naming who is going to make healthcare decisions for you in that healthcare power of attorney, and you are leaving them instructions for what your healthcare should look like in that living will or that advanced directive. And living will and advanced directive, they are the same term. Maryland uses advanced directive, but lots of other states and lots of people just refer to it as a living will. They are the same thing, however. So with the healthcare power of attorney, we are going to nominate, very similar to the financial power of attorney, we're going to nominate a person or persons that is going to make medical decisions on our behalf. Similarly, we're going to say what it can cover, and we're going to say when it starts. And for most people, that is when their healthcare provider says, our patient isn't responding to us anymore due to cognitive impairment or any type of other impairment. And that is when we're going to look to your healthcare power of attorney to act. From the legal perspective, The big legal component in this is the HIPAA release. So HIPAA has to do, it's federal law, it has to do with your medical privacy, saying that your medical records are private. There are lots of exemptions in it, but for the most part, even spouses could be restricted from looking at someone else's medical records, all right? So having that HIPAA release to say that your healthcare power of attorney can know that information, can talk with your doctors, can look at your lab results. As my wife always teases me, she can know how high my cholesterol is. They want to have that information so that they can make informed decisions on your behalf. So when it comes to the advance directive or the living will, there's really no right or wrongs with this, all right? You have the authority to decide what you want your healthcare to look like. We really tend to focus on end-of-life care, things like being put in a persistent vegetative state or a coma, having an end-stage condition where you're likely to pass away very quickly or your death is imminent, or having a terminal diagnosis where to a reasonable degree of medical certainty, there's no cure. And there's no rights or wrongs with this. I have some people that will come into my office and say, I never want to be on a ventilator. I never want a feeding tube. I never want to be resuscitated. That's it. And it's, 2 sentences and we're done. And then I will have other people that will come in and say, these are the types of care and procedures I want. And they'll include personal things like they would like a certain type of music to be played by their bedside, or they'd like their grandchildren's picture on the bedside or something along those lines, or more importantly to them, maybe that they want their care carried out with respect to their religious wishes. So all of those things are good and appropriate to put into this document. The main purpose is we want to make sure that our healthcare agent knows what we mean. So if you are of a particular religious belief, you want to make sure that the person that you've named knows exactly what that means to you. So when we do this type of document, the big question that always comes up is what you'll see at the bottom of this slide, the MOLST form. This is the Maryland Medical Orders for Life-Sustaining Treatment. This is not an advance directive or a living will, but it talks about a lot of the same things. So the difference is that MOLST form is designed to be used by medical providers, and it is standardized throughout the state. Whether you go to Johns Hopkins Hospital or Anne Arundel Medical Center or Doctors Hospital, they all have that exact same MOLST form. And it asks a lot of the same questions. If you go into full code, would you like to be resuscitated? Yes or no? And it is quite literally boxes that are checked off, and then the medical provider signs at the bottom of that. It is not a legal form, it is an administrative form, but it is very important. And I like it, it's good. But whomever you name as your healthcare power of attorney needs to be aware of your MOLST form, because people may do multiple MOLST forms in their lifetime. They may do one when they're admitted to the hospital, and then if from the hospital they go to a rehab center, they'll do another one at the rehab center, and maybe a year or two later, they'll have a different hospital stay and do a brand new one. And because it addresses a lot of the same questions and concerns that the advance directive does, whomever your healthcare power of attorney is should be looking at that form and making sure it is consistent, particularly because it is the medical provider that signs that. And I'm sure they all do well and intend well, but perhaps a box did get checked incorrectly, or perhaps you are not competent when that MOLST form was filled out because of your medical condition. So being aware of that MOLST form and how it affects the advance directive is very, very important. Okay, so we're going to wrap up here, and I'm going to spend some time answering as many questions as we have. But the main thing I want you to take away from this is to not be afraid of these documents, to get prepared, to feel empowered to do them, and talk with others about this. Decide who you're going to put in charge to do this, and make sure that you are in a position to age successfully and not have any difficulty with family members or loved ones not understanding or knowing what your intentions are. So I'm going to stop sharing my screen there, and I will open it up to Pam to field any questions.
Miss Angie Burns, you can go ahead and mute yourself.
How do you change the person you appointed to be your power of attorney, say a year after you've already prepared the document?
So that's pretty easy to do. You can't amend powers of attorney, but essentially what you do is you revoke the old one and complete a new one. If you already have one in place, it's a pretty quick process. If that power of attorney is already acting on your behalf, you should provide them notice. Maryland doesn't say what kind of notice, but most people will send a certified letter saying, hey, that power of attorney I did back in 2012 is no longer valid. I've updated my documents, and that is sufficient. But you can always, as long as someone has capacity, they can always revoke and do a new document.
Okay, thanks.
Hello?
Yes.
Okay, sorry, I got so many questions. The MOLST, MOLST form, do you do that form? I know you said the doctor signs that, so you have to make sure that the doctor does that when you're talking about the medical person's authority, and they need to get that form, and you need to have that form. Am I
Yes.
clear? Oh, okay.
Yes. So some doctors, if you go to your regular doctor's office for an annual checkup, they will have them there, and some of them are willing to complete it with you in advance, but that is rare. Most of the times it happens in a hospital or a nursing home setting. So for example, my wife had minor surgery about a year ago, and I got to see how it sort of plays out. You go into the doctor's office, whether it's a physician's assistant or a nurse practitioner, he or she comes in and they will go over the form with the patient, and they will check the boxes, and then that medical professional will sign that document, and it stays in your file as long as you are in that, whether it's the hospital, the surgical center, the rehab center, as long as you are there. What's important about that form is it addresses a lot of these questions. So in my wife's example, I already had her healthcare power of attorney and her advanced directive, so I knew what she wanted, and it was very consistent with what she had previously done. But if, for example, I showed up at a nursing home and my wife was in the nursing home and I asked to see that MOLST form, perhaps a box got checked wrong. I, as her medical power of attorney, could ask for that form to be updated, okay? But Maryland adopted that MOLST form back in 2016, and it is standardized throughout the state. So any type of medical care you get in the state of Maryland, if you're being admitted somewhere, you're gonna see that form.
Okay, thank you.
Yep.
Miss Monica Perry, you can unmute yourself.
Directly to the Russian people. Hi, I missed some of the conversation in regards to the trust, but my question was, if you put a home in an irrevocable trust when trying to get Medicaid, should you do that 5 years prior to thinking about applying for the Medicaid? And does the revocable trust take the home out of your name as well, or is it just the irrevocable trust?
So both trusts will take the property out of your name, and the trust will now be the owner of that property. The reason that you need an irrevocable trust for Medicaid purposes is because with that traditional revocable trust, Medicaid will say, go ahead and revoke it and take the house out. If you're trying to protect it from Medicaid, you need to have it be an irrevocable trust. And
Okay.
with your question about that 5-year look back period, yes, that transfer has to be done outside of that 5-year look back period. If you transfer that property to that trust inside of that 5-year Medicaid look back period, they will view that just as if you had gifted it to a loved one, and you'll get a penalty for doing that.
Thank you.
And maybe someday you'll also own a Domino's. Can you be free of hair breakage worries?
Miss Sheila Miller, you can unmute yourself. Ms. Miller?
Yes, I don't have any questions at this time.
Okay. No problem. PA Harrison?
Okay, a question on the MOLST form. Say, for instance, with the MOLST form, you're in the process of getting all of your paperwork prepared and it's not finished, and you have a medical emergency. You still will have to complete that MOLST form. That's going to
Correct.
be given to you in the hospital regardless of having had your other documents prepared.
Correct.
Okay, so you just have to do due diligence to make sure that you have all your boxes checked. Okay.
Right. And I would say that the bigger thing is, for most of us, talking about getting sick and dying is no fun. Nobody wants to do it. And so really having that conversation with yourself, or maybe some of your friends or family members or religious leaders, to decide how you feel about those things is probably the first step in doing that, and oftentimes the most difficult, particularly with something like COVID that we've dealt with for the last couple of years now. That is one that, when we talk about sort of the big three things that people are worried about, it's not necessarily an end stage condition. It's not a persistent vegetative state. It's not a terminal illness, because people do recover from it. So you think about something like that and say, if I had really severe COVID, would I want to be placed on the ventilator with the hopes of coming off? Or do I really feel strongly that I never want a ventilator? So having those personal sort of discussions with yourself that are really difficult tends to be the first step in that. And it is not easy, but I do encourage people to do it, even if it's just scheduling an appointment with someone, because someone like me might bug you to do it. That would be my best recommendation. But to your earlier point, yes, right now in Maryland, if you're admitted to a hospital, even if you don't have an advance directive, they're going to ask you to complete that MOLST form.
Okay. Thank you.
Monica Perry, do you have another question? You can go ahead and mute yourself.
Oh no, I asked both at the same time.
Okay.
Thank you.
Let's see. Pierre Harrison, you still have another one?
Uh-oh. Yeah, I still have another question.
Okay.
Cost. Say you want to get all of these things done, your directives, your will. What would be, say you're not looking at a $50 million estate or something, where cost would be no problem. What would one expect to pay to have these documents prepared?
Sure. So our firm, when we talk about just doing a will, we charge $750 to do the will, and $250 for each power of attorney. And I include that advance directive with the power of attorney. And if you want to get all three all at once, or all four all at once, we package that together for $950 for a single person and $1,500 for a married couple. The other thing I will say is, of course, I think Byrd Byrd, we do excellent work, and our powers of attorney are the best in the state. But for people that are really worried about cost, the Maryland Attorney General's website has both a financial power of attorney and an advance directive on their website that you can print and use as a PDF. The financial power of attorney, you do have to get notarized. The medical one, you do not. You just need two uninterested witnesses, so non-family members, essentially, maybe a neighbor or something along those lines. And I've used those at volunteer events. They are good. They're certainly way better than not having anything at all. So it's nice that Maryland offers those, and people are used to seeing them too.
Okay. All right. Thank you.
You're very welcome.